Well, a very good evening to everybody. Tarun Khurana, welcome to another webinar of IIPRD and Khurana. A very warm welcome. I have a colleague of mine. We are sharp at 5:30, and we have a very interesting topic today. We've sort of moved on from the regular bread and butter prosecution matters to litigation to many other very finer aspects of IP. And we thought it's prudent for us to have a session which sort of takes us a little more up and understand the issues pertaining to IP strategy in general and how companies should formulate and practice their strategy on the intellectual property side of it, so as to ensure that their portfolio is more holistic, is more appropriately developed and managed. And therefore, a very apt speaker on the topic, David, has become a close friend and associate in the last few months of our relationship. And I thought it's very important for us to have him on this session so as to sort of explain to us, give his perspective on various issues over the last almost about 30 years that he has been a part of the industry in. And would request everybody to please be on mute during the session. We have questions at the end for the last 10 or 15 minutes. Now, without further ado, David, why don't you give us a quick background so that we're all on the same page, and then we'll start off with the discussion. A very warm welcome again to everybody, David.
And thank you very much for giving me the opportunity to talk to you and the others about the ideas I'm developing about better use of the IP tools and weapons to help scientists, engineers, inventors, creators of all sorts appropriately profit from their creations and bring the benefits of great new ideas to the public by creating profitable enterprises that can be sustaining and get the benefits of ideas from the laboratory or from your own workroom out into the world. You will have to forgive my extremely inappropriate sense of humor, but there are some serious and hopefully useful ideas buried in the speech. I will start the introduction by saying I'm a college dropout. I was a physics and math major at the University of Chicago, and after 3 years of the 4-year program, switched and went to law school a year early, did that, was a general litigator, became a lawyer in 1976, was a general litigator doing airplane crashes and securities fraud and antitrust. After about 3 years of that, I decided to take the patent exam and focus on what I thought would be a more interesting area of combining the world of science and engineering and the world of the public and policy and law and those things. Passed the exam, went to a first patent firm, went to a second patent firm, eventually made partner there, started my own firm in 1996. We grew to 20 or 30 lawyers at our height. I left that firm in 2013 and been a solo in IP strategy focus since then, which I characterize as rather than building the castle that protects your treasure with the moats and the walls and the archers and so on, the various things of patent and trademark and copyright and trade secret that people use, I now try and architect castles. I try and come up with the plans of what are you going to do with IP, and my new mantra is doing IP well is hard. Doing what any patent and trademark and copyright and trade secret lawyer does to protect things. It's a subtle, tricky area of the law that requires usually expertise in the underlying science and technology or music or whatever, as well as the law. But that deciding what to do, the strategy layer above the actual building layer, is even harder. So the first question on our agenda is the parameters, the metrics, the analytics that should go into people's thinking about building and using their IP. Tarun, I don't know if you want me to ask you my own questions, if you want to get in there. I don't mean to steal your thunder.
Makes my job much easier, David. So whatever is comfortable, absolutely.
Okay. And the first thing I wanted to say is that this is actually a really hard question because, in my view, the right analytics and metrics are very subtle. If you just count how many patents you have or how much royalty you're earning from your IP, especially if your model is to make and sell some product or service. The main reason for the IP is to protect your sales and protect your profits and create value in the company so you're not just a commodity, to protect those margins, to give people a reason to buy your product versus another's, to pay, to be in some way special, different, interesting, useful versus the alternatives and the competitors, so that they're willing to pay a good price, not just the cheapest price. And so it gets very tricky as to what you measure in terms of good versus IP strategy. And you have to be careful what you measure, because it's an old cliche in business that you'll manage to whatever it is you measure. So if you decide that we want to incent the filing of patents and be the world's largest patent filer, you'll get that, but it may not be high quality and it may not pay off. So it's a hard question. IP itself, even before you get to the strategy layer on top of the IP, is very subtle. And what makes good patent versus bad patent? It's complex, it's elusive. It's often hard to tell before the litigation or the fight. Will this patent survive and be broad enough to cover the competitor's activities? So too with trademark and copyright and trade secret. There are, of course, markers of things that are weak or bad or lesser, such as claims being long and too narrow or claims being way too broad. There are ways to know more about what you can call it the best prior art or the worst prior art, whatever the strongest prior art is to attack. And if, do you cover that? Did you adequately claim around it? And again, so too with trademarks and generic and descriptive issues and copyrights and idea versus expression and trade secret and precautions. But it's not a trivial thing. And again, it's not just patents. I urge you to build in your mind a 4x4x4 cube of IP space, which is one of the tools of IP strategy, where your x-axis is patent, trademark, copyright, trade secret. There's obviously other forms of IP, semiconductor chip, plants, other things, privacy and publicity, but those are the big four. Y-axis would be the big activities, litigation, licensing, protection, and deals. And perhaps think of it in that order. You never hope to litigate, but that's where you find out whether you did it right or wrong. And also in the deal stage with financing, with venture capitalists, private equity, with acquisition, and so on. You're building your portfolio. You're taking the earliest steps so that you build a foundation for later. And your Z-axis being perhaps physics, chemistry, biology, software, and design, so that you have the different technologies that go into things like my beloved DNA synthesizer had new chemistry in order to do new biotech things. It also involved complex software and wonderful mechanical engineering of zero residual volume valves, so it'd be very precise in what it pumped out. It was a box that produced pieces of DNA where it used to take PhD students 2 or 3 years of stirring and cooking in order to just make the piece before you could ever run the experiment. It was a marvelous, marvelous set of breakthroughs. But it was all of these levels. There was litigation, there was licensing, there was patent, there was trade secret, and there was physics, chemistry, biology, and software all involved. And you have, not every product has all the levels. When you represent Cartier watches or other luxury goods, a lot of the technology levels collapse. But at least you want to be asking the questions and thinking of that, so it's not just, oh, I filed a patent, therefore I have an IP strategy. It's far from that simple. The key really is, what is your sustainable competitive advantage, which I've even started to abbreviate as SCA because I use the phrase so often. And I think, at least from the point of view of an IP lawyer, sustainable competitive advantage is the key to life and key to happiness, which is why I think of IP as important. Why are you different, special, valuable, interesting, important, worth buying in the first place, and worth paying a premium, not a generic price, worth investing in? And for the talent you need to hire, why are you worth joining or being the place they choose to go to work? Why are you worth having alliances with and having cross-licensing with people? How do you use those sorts of cross-licensing alliances as judo moves to make sure that you use the opponent's strength against them rather than just engaging in endless litigation and slogging battles? For instance, most cars, to me, look the same. Tesla has a huge market value today because it's different. It's interesting. It stands out from the crowd, not because of the sales, not because of their factories, not because of the land they own, because of their IP. And if you think about who's the leader in search or social networking or sharing your home or taxi by telephone, who's the leader of the catalog, the category, those trademarks become very, very important and give a major advantage, even if it's not patent-based. So the parameters come out of the toolbox and the tools of IP and of IP strategy. And as I say, it's hard to do just regular IP well, and I've done it for a long time, since about 79, 80, and still do a bit today. But it's subtle. It's, of course, invisible. It's usually poorly taught in business schools and in science and engineering schools. Even many attorneys don't know much about IP. So building the good castle is hard. Designing the good castle, also very hard. Choosing what IP to deploy. And appreciating what each tool can and can't do, screwdriver, hammer, etc. It's good for one purpose, not the other. If you have a screw and attack it with the claw end of the hammer, if you have a nail and you hit it with the back of the screwdriver, things are going to be hard. And good IP takes a good IP lawyer. Good IP strategy takes a team. It takes a team of business and science and law mixed together to do well. And if we have a few more minutes, I'll try and summarize the tools quickly. Tarun has some backup materials if I go too fast. And that'll give you a sense of what these parameters properly are. So a 5x2 matrix. Pretend you're the client, you are an entrepreneur, you're going to be hoping to seek VC, venture capital financing in a couple of months. How do you think about your IP strategy? One tool is draw a 5x2 on a piece of paper, patent, trademark, copyright, trade secret and licensing, attack and defense. What are we doing? This forces, these 10 questions, these 10 boxes force you to think about your IP in a much more holistic way than, oh, we have an idea, let's patent it. And it encourages you to think about the full 360 landscape of IP rather than focus on any one. Now, again, if you're a biotech company or a software company or a luxury goods company or a servicing company, what you'll fill into the 10 boxes changes, but you ought to be thinking about all 10 issues. Another tool is a 6 cycle of IP management, which the steps on that cycle are budget, team, map, brainstorm, protect, and use. Budget meaning pretend as a startup I have $100,000 budget for right now for this next year. Well, maybe about 10,000 of that, or a tenth, might be worth devoting to IP issues. I'll decide which ones, but first I've got to pick how much and then triage within how much. And again, as a metric and analytic, if you ask a company, why is your budget? Not what is your budget, but why is your budget? You'll get an idea of how good the thinking is and start measuring how good the IP and IP strategy is. Not we got 3 ideas, so we filed 3 patents, but we were able to vote some appropriate fraction of our total budget to protecting the rest. And within that budget, these are the things that we triaged as most important. That's budget. Team, I mentioned, it's a combination of a top business person, top science engineering person or design person, and a good IP attorney thinking together about what might we do and what do we do next, controlling the IP, because it's not just legal, it's not just business, it's not just technical. Map is the searching that we'll talk about more, know what's out there that others own, and as you develop stuff, what you own, the IP audit. Brainstorm is, let's think about what we're going to do next. And now we're doing it in the context so that we're crossing this dangerous minefield of other people's IP, not at midnight, blindfolded and drunk, but with some sort of a map and idea where the landmines might be. It's still dangerous, but it's less dangerous if we do the work. Protect is what's considered conventional IP, filing on the patents and trademarks and copyrights, taking the precautions for trade secrets. Important, but important in context of a larger story. And use, meaning when you get the IP, don't just put up certificates. These are the 26 patents we got. What are you doing with them in order to build alliances, build value, have a sustainable competitive advantage? The least interesting thing you can do with IP is litigate. You've always got to think about how would a litigation work out. It's always the test case is, I might have to fight. I study karate. I've been able to stay out of fights, but it's always the test. How would this work in a real fight? You want to have good fitness, good strength, good tool set, good weapons, so that people choose to negotiate with you rather than fight. But again, if you've just obtained the IP and you haven't used it, you haven't gotten full value out of it. Another tool is a 4-level pyramid of IP value. Not the IP is worth this number, but working your way up to make it more and more valuable. The lowest level of value is having a portfolio. That is to say, you can at least say to the VC, we have 6 patents in 7 countries, we've done this in trademarking, just rattle off stuff. It may be that upon scrutiny, this stuff isn't any good, but certainly at early levels of financing, angel and first stage VC, they often don't look very hard. And that you have it at all is a first level of value. A second level of value is valid scope. That is to say, those rights, whatever the most important one, would stand up under attack and be broad enough to cover competition. Third level of value, freedom to operate, FTO, or right to use, RTU. Extremely important. This is where attack and defense, the two-sided nature of IP, is really emphasized. Who could sue you? What are the worst threats that are out there in terms of what might attack you? You'll often see a first-time or naive entrepreneur say, oh, there's nothing like this. You know, we're completely safe. It's totally new. There's always stuff. There's always the most dangerous attacks. And if you don't know what they are, they're going to come at you as total surprises versus being able to deal with them early. There's some wonderful disaster movie where an asteroid's going to crash into Earth, and if they can push it to one side early, it doesn't take a very strong push. If they need to push it aside when it's really close to Earth, better. Even that is only the 3rd and 4th stages of IP value. The highest and best in terms of thinking about valuable IP is I also know what the next best alternatives are. Cipro was a antitrust case I got to work on after the patent case. The pharmaceutical company was using reverse payments to stop competition. And Cipro was a wonderful drug when it came out, and it was the only thing that was good against anthrax, which in US, you know, after 9/11, there were envelopes being mailed with white powder. People were freaked out. They were thinking of nationalizing the patent to grab it. But now there's, you know, 5 or 6 other treatments for anthrax. It's no longer so unique. So IP value is never static. The 4th dimension of time, as well as the cube we've built, the 3 dimensions of IP space, is critically important. Indeed, IP is the law of change, of new stuff. So what are the next best alternatives? If there aren't very many good alternatives today, valuable. Tomorrow, though, there may well be other alternatives that don't infringe at all. They get to the same result in a totally different way. You're building a bridge where previously people only had ferries to cross the river. Well, you want to have a solid foundation. You want to have it be broad enough and strong enough as a bridge to not collapse, not just be pretty and then can't take any weight. You want to make sure you own the land on both sides so that you find out you haven't built the bridge and then someone else has a claim to it. And it's, you know, you can charge a big toll for that bridge until the nearest bridge isn't 20 or 50 miles away. Someone builds it a few hundred meters away. Now suddenly the value of your bridge has decreased. So the values are constantly changing, of course, usually much, much faster than they do for real property or personal property, factories and equipment, personal property, or the ownership of land. And around the world, you find that many of the new, interesting, valuable companies are not based on the land they own or the factories and equipment they have. They're based on the intangibles, the ideas, and how they're using them. Anyway, so the next set of tools is diligence in a New York minute. 5 quick questions the VC ought to ask you. They probably won't until you get to later stage financing, but you ought to be constantly asking yourself to measure, do I have good IP? And you could think of this as 2 legs, 2 arms, and a head. You know, what are the infringement threats? What are the validity threats as the 2 legs, the basics? The 2 arms would be the freedom to operate and the next best alternatives. And the head would be the R&D, what are we going to build next? And I have a short 2-page article you can get from Tarun outlining a series of questions under these 5 topics. And if you ask yourself that, if you're successful and you become the VC and the angel, you ask the companies this, in 5-10 minutes, you can find out, does the person know what the worst freedom to operate threats are, what the worst prior art is, what the best arguments of non-infringement might be, and so on. What's the menu of R&D choices going forward, and within that menu, which 2 or 3 are they going to pick to actually pursue and why in terms of there's no IP there, or we figured out cross-licensing to get through others' IP. And then you can engage in full diligence, deeper searches, and so on. One more tool that I do want to mention is 3x5 index cards, either in actual paper or using computer tools. You just label them IP 001, 02, 003, and you give it a title, 4 to 6 bullet points. Why are we different? Why are we interesting? Why are we special? You get 20 or 30 of those cards on the table in front of this IP committee. You can pick and triage which ones are most important, which ones we can pursue. And of course, what are the key words that we can search out? What are the companies and classes that we hit? Come up with additional keywords. You get a sense of what's the prior art, what's the freedom to operate issues, and you can start seeking who are going to be developing alternatives to me, who are future allies or competitors or suppliers or customers, or a big company that might acquire me because they're active in the field. And these are good skills to have as you become successful and become your own angel. So final point on question 1, metrics and analytics are hard. I would love to see an app and some artificial intelligence to help at least do the first level of this, to help people inexpensively, to measure the right things and combine that information the right way, give a grade, give a rating, give recommendations, suggestions for improvement. Please let us know if you want to help build one. It's difficult. So, question 1.
David, absolutely. I think feel free to go ahead with the agenda that we've outlined. I think examples on some specific instances that you've been a part of where you devised or changed the current IP strategy that a company was following. Maybe they were defensive and you sort of wanted them or configured them to become more offensive, or any other change, minor or big, that you've proposed. I think such case studies would really help us better appreciate what according to you makes more an important parameter.
I will try and give it and be appropriately respectful of current client confidences and so on. Try and deal with some war stories with either made up names or things that are sufficiently ancient that it no longer matters. My personal favorite, again, relates to this DNA synthesizer that I got to work on because it was a really groundbreaking technology. And in fact, we did multiple litigations for the client. At one point, they actually shipped me one. And so if you had visited my office in the old days, there was a glass case with a DNA synthesizer sitting in there. And it's one of the most exciting things I ever got to work on. These patents really gave a hugely better way to make short pieces of DNA, which is, of course, now critical for the RNA technologies and vaccines. It's for diagnostics. It was just a very basic tool in a biotech tool set. And they sued to stop the infringers. Perfectly reasonable thing to do. It turned out the technology was so good and so great that nobody could resist infringing. They had nowhere else to go. So we were in a suicide pact where they were either going to kill the patents or we were going to kill them. There was just no way out. And the litigation was dragging on, and like any patents, no matter how good, there's always something there as weaknesses. Some I knew, some they knew. Non-infringement arguments, you could have lost. And anytime you go into a case not recognizing that you can lose, you're just kidding yourself. And the way I remember it, and of course I'm the hero of my own story, so this may not be what actually happened. But the way I remember it is I realized that the better answer was for them to start licensing the competitors at a good royalty rate, enough so that our price would remain very attractive. Even if we were the IBM and the price leader, people would not be able to tremendously undercut us because, again, it was in a sense irresistible. And the head of the company, who was a fierce, brilliant guy, I managed to persuade him with others that changed the strategy from stop everybody to license everybody. And it went on to be licensed to basically the whole field, 20 or 30 leading companies. It's, I think, still the standard technology being used today. And, every once in a while, someone would come along and say, I'm going to infringe. I don't believe in your patents. And we'd have to sue them again and again and again. But up through patent expiration, it was earning royalties. And it was a real privilege to help make that difference and get the technology out there. There was also, with respect to privilege, attorney-client privilege issues. When you do patent prosecution around the world, different countries have different laws for what's privileged. We were in front of a judge, Judge Orrick, who had ruled that patent prosecution was not attorney-client privileged. It was technical. You had a duty of disclosure to the patent office. Many courts had ruled that it was, but he and some other courts had ruled, no, it isn't. So we wanted to keep documents protected. There was good reason for that. And I took him on and said, you should change your mind. And he did. So that was another wonderful moment in that case. Another case, we were representing a financial institution investing in companies. They were going into those big polypropylene bags you see at construction sites. There was a major competitor, the company we wanted to buy, and the competitor were locked in a patent litigation. Each had their own IP. They were each suing the other, and no one knew, were we going to end up with effectively 100% of the market or zero because of which way the patent suit would go. It was going to be a year or two before the case was decided. People wanted to go ahead and do the deal now for reasons that is financial and not relevant here. And I was able to propose and help persuade people, you guys should cross-license each other. And then who's ever selling the most and based on what the patents are worth and so on. And the suit went away. The deal was able to go forward. There was another way to look at it. You have this fierce opposition. There's no way to push harder left or right, but you push at a right angle and it breaks open. Early on in my new solo practice as an IP strategist, I was hired by the corporate lawyers who were working on the financing of Pinterest. This was a private equity deal, let's say $200 million, let's say $1 billion or $2 billion valuation. It wasn't minor. But they had thought about IP relatively late in the game. They came to me as a solo and said, you know, what can you do at a small budget really fast to figure things out? And that was in many ways the start of my formally developing this tool set and the IP diligence tools that tries, I'd been involved in previous diligence where you list every single patent, trademark, copyright, trade secret around the world, where you look at every single file, you look to see for problems, you make these huge lists of what's out there, you check the assignments, you check the inventorship. I mean, you know, full diligence, absolutely needed, very good idea. I'm not knocking it, but there are things you can do before that which are really valuable. Another case, got to represent a cigarette racing boat, which was these long, very fast boats. They were used in Miami Vice to smuggle cocaine, and then the Coast Guard had to buy them so they could catch up with the smugglers. And they came up with the boat Firefox. Their competitor Donzi was announcing the Foxfire at the Chicago Boat Show. And they called me, you know, the boat show opens to the public Friday, and here it is, Tuesday or Wednesday. We're at the boat show. We're putting together our exhibit. We have this problem. Can you get them stopped tomorrow? You know, before the show opens. We were able to get a preliminary injunction in Chicago, and the typical of Chicago litigation, the lawyer on the other side was a personal friend of the judge, who was the brother of the governor. And, you know, when he gives me my injunction, he says, I'm sorry, Bill, I have to rule against you. You know, Chicago's notoriously, corrupt's perhaps too strong a word, but sometimes informal in what they were doing. This judge was not. And we were very lucky in being able to get a very fast injunction. That happened also in a trade secrets case where DuPont had taken technology for making titanium dioxide, which was based actually on Nazi rocket engines. Astonishing. But titanium tetrachloride burns very hot. In fact, it's hard to make the right materials that can contain the burn, something like rockets. The other method of making titanium dioxide, which is the white pigment, that's the second most common pigment after carbon black, it's billions of dollars, is with sulfuric acid and quite messy. Kerr McGee had been trying to steal this technology for years, and there's reported cases in the book in the mid-60s of their doing that. And they were hiring our chief engineer from the Ohio plant to go to Saudi Arabia and make a new plant for them, and would have resulted in the leakage of this very serious trade secret. And again, we were able to get a very fast injunction from a judge and explain to him the value of this and the story of this, get limited relief, but enough relief while he was still in the US to save it. Another situation, we had a luxury goods client that wanted to bring their enforcement budget for trademark infringement of their fancy luxury goods down to zero. And given the amount they were spending on advertising, on physical security guards, on the fact that, you know, it was a $300 good leather purse, but it sold for $1,000 because the Gucci name was on it, or it was a Cartier watch that, you know, again, was $1,000 of engineering, but it sold for $10,000 for the Cartier name, Van Cleef & Arpels, you know, you can name these various marks. The trademark really mattered, and we worked hard at convincing them that the budget, zero was right, the number, not the right number, you know, too much, too little, but pay attention to it. Another situation involving the comic book hero Conan the Barbarian. This was something I was involved in, but my then senior partner really thought of. There were two factions that owned some of the rights, and they didn't get along. Maybe they hated each other. And so if you wanted to make a Conan movie, the first one would say, okay, I'll license you for $1 million. The second one would say, well, I'll license you for $500,000. They'd come back, I'll license you for $250,000. And they bid themselves down to zero. And he had the absolutely brilliant idea of take the two factions, combine them into one corporation, have all the fights take place in the privacy of the boardroom, but to the outside world, it was a single, strong, unified entity that owned all the rights. And he was able to relicense, and I got to work on some of this stuff, comics, books, movies, merchandising, and so forth, and made a lot of money for a lot of people. So those would be some of the examples that I've gotten to do. And of course, I'm working now frequently with small companies that have very limited resources, and they're trying to figure out what can we do with IP at very tight budgets that's going to make a difference both for our sake and when we go to seek financing, be reasonably impressive to people. And each of those are wonderful things. But I think I shouldn't get too much into specifics there.
Sure.
But I guess the story, the rule that comes out of that, just to finish the thought, is we all aim for victory as lawyers, and we should. But when you can encourage your client, because you have to follow the client's instructions, to aim for fairness as well as victory, you can often do them much more good than simply following what they initially want and just trying to win what they want. You could be a counselor saying, this is what's going to make sense for you and really help you, and not just earn me the big fees of 2 more years of fierce litigation.
So David, while you talk about IP due diligence and what parameters, apart from the basic formality parameters like inventors and IDSs were filed or not, and was the priority appropriately taken or claimed, and you know, the basic stuff on the due diligence side, what other parameters do you usually look at when you're doing due diligence for a company at large? And also, if you could supplement that with one of the questions that one of the attendees is asking Prasad about, and this is something that gets asked to us also very regularly, that when there's a startup with cost constraints and even otherwise, and they're developing a core R&D product, say in the CBD diamond space, or in a very core technology where there is a possibility of keeping a large portion of the technology as a trade secret. How do you decide whether to keep it as a secret when it is possible to do that versus file a patent? You know, so what's your take on that front?
So that's a super interesting, super important question. And there is, if you start looking at the articles, some very good lists of 4, 5, 6 factors that you ought to work through your thinking. For instance, is it like a pharmaceutical where it's highly regulated and you have to disclose, and therefore you're never going to keep the formula secret for what the drug is because of regulatory reasons? Is it an area where there's a lot of what I've learned to call pub talk, where your factory is close to the other guy's factory, your workers are going to be mingling with their workers, and no matter what the rules are, there's going to be a lot of loose chit chat? How good are your security precautions, both your cyber precautions and your physical precautions? Is the technology going to be obsolete in 2 or 3 years, the way a lot of software keeps on moving and improving? Or is it like the invention of spreadsheets, where it's important 20, 40 years later? Is it something where it might be important even beyond the expiration of most patents, 20 years? So like a Listerine formula and trade secret, or the Coca-Cola formula, you might be able to get 100-year protection with trade secrets over patents. You know, what's the likely life? And you know, these are all guesses, and you're not necessarily going to be perfect, but there's some of the factors that go into it. But I'll tell you my favorite strategy, which is imagine yourself as a DuPont factory making a new Teflon, whatever it is, plastic. And the factory has multiple stages. And I would look to patent 1, 3, 5, and 7 and trade secret 2, 4, 6, and 8. Because if the choice is, are you going to be rich or are you going to be happy? Are you going to patent or are you going to trade secret? Are you going to both? Try and use all of patent, trademark, copyright, trade secret to protect that sustainable competitive advantage. So as you think through that core technology and you start creating a series of my index cards, you may find that there's 5, 10, 20 inventions that go into making it work well. Some of them may be easily reverse engineered, which of course is really a first question. Can the other side pick up your product like a circuit board and, maybe they have to use microscopes or very fine analysis, or if it's chemical, very fine tools to figure out what you're doing? Or is it process parameters like a recipe? For this, I like to use a brownie because I like chocolate. But whether I cook that brownie at 350 or 340 or 360, you can't tell just that it's a delicious brownie. Whether I cooked it for 20 minutes, 19, or 21, you can't tell. Whether it's plus or minus 1% or plus or minus 0.1%, you can't tell. We had a case where some lithium battery technology was stolen very on in the history of lithium batteries, and they're still mostly being used by the military in outer space, where they knew how big the part was, but not how precise it had to be. And if it had to be plus or minus 1%, it'd be cheap to manufacture. Plus or minus, a millionth of an inch, a millionth of a centimeter, because that had to be exactly right. It was a much more expensive part, and you couldn't tell from the part what the precision was. You could tell from our blueprints, which were stolen, that had the plus or minus in there. So if it's anything like a recipe, the how do you make it, not what the final product is, very suitable for trade secret precautions. But if possible, look to patent some stuff and trade secret others. One trick that exists in America, and I'm not sure it exists in other places in the world, is when you file a patent, that is typically published 18 months after filing. In the US, if you file a US-only patent, and I'm not going to seek foreign protection, you can keep it secret until it issues. And along with A and B, patent and trade secret, as you look at your technologies, you may find some of them are suitable for one country only filing, depending on what your country permits, that doesn't extend elsewhere. It used to be that the US was like half the market for my high-tech goods. Then it declined, I think, to maybe a third. After Trump, we're down to a quarter. It may only be 10% in the next few years. How valuable patent in just the US is a moving target. But then you can keep the technology secret for years, fight with the patent office about the claims, and then if it ever gets stolen, let the patent issued and have it be a backup weapon. So it's part of thinking through how do you decide. Trade secret protection, so long as it works, is great. It protects you in every single country against all competitors, subject to reverse engineering. And of course, subject to, if it's recipe information, how do you detect infringement? Another critical issue in which you should choose. If you can't tell whether your competitor would be infringing when they come out with this product, because there are other ways of doing it, maybe more difficult or expensive, maybe even better and cheaper than yours, how good is a patent going to be? You want to look for patents on end products that you can come forward with, measure and tell, say that's infringing. Process ones have to be thought through a little more carefully, though again, there are extremely valuable process patents out there, and there's ways of pulling that information from defendants, but everything with a cost and a risk. So I think the right question is not should I patent or trade secret it, but what is my budget? What is the key to giving me the sustainable competitive advantage, and then creating the best barriers within budget around that? And again, there's a lot you can do for $10, $100, $1,000, $10,000 that makes sense. And if you're spending your time and your effort and your life's blood building up this company and product, yes, you don't want to spend half your effort on protection. You have to focus most of your efforts, 90% of your efforts, whatever, on creating the product, the team, getting it out there, all those things. But some fraction of the total effort ought to be protecting and saying to yourself, I don't want it to be easy for people to copy me. I don't want it to be easy for someone to sue me and say, you copy. I don't want it to be easy for the big company to come along either with their IP or IP that they bought from someone else and stop me, especially the more disruptive and more important and more core I am, someone's going to want to kill you. I got to work on a merchant's credit card, which is going to replace Visa and MasterCard, which are very big in the United States. And we had to look very closely as to what patents in particular were owned by other people, because Visa and MasterCard were going to hate our product. And even if they didn't own the patent, they could buy it from this other little company and then sue us on it. So it wasn't just which patents they owned, though you start with that, but also which patents we might infringe owned by anybody. Which one should we cross-license? Which one should we do an opinion of counsel of invalidity or non-infringement? Which one should we design around? But when trade secrets break, they break completely. Secret's out there, it gets published, it's gone. So having multiple secrets, having multiple patents, having layers within layers, so it's not everything on the moat, everything on the wall, everything on the archers and knights. You've got layers of defense. And again, a good VC will be really thrilled to see that, because it shows that you've thought it through well, you're thinking about the issues in the right way, and the same things that thrill a good VC should thrill you, that you're investing your money in things that are going to make a difference. By all means, have good precautions. Don't forget to use trademarks and quality as well. Trademarks and trade secrets are ancient forms of IP that go back thousands of years. Patents and copyrights, more recent creation of statute, but all can be used and deployed, or at least thought about, depending on what again, if it's the Harry Potter book, there's probably no patent there, but there's very valuable copyrights, very valuable brands. So that even if something breaks, you're not gone. You think about a jet that has triple redundancy in its controls. One of the control lines is severed. There's still a way to land that thing safely. I've never parachuted because I'm a coward, but I understand that most parachute carry a backup on their front. My son had a rule: if it's important to carry a backup.
All right.
Does that approach that question for you?
Absolutely. Absolutely, David. On the due diligence side, if you could maybe take a couple of minutes, and are there some models like the models that you talked about, the 5x2 model on the strategy side? Are there some models that, or some parameters specifically that you think other companies usually don't consider or cater to at the time of undertaking a due diligence or an evaluation exercise? Some very specific points if you think that usually are bypassed during diligence exercises.
Yeah, I think people don't consider IP at all well during these exercises, because you see companies like the Uber taxi company getting these huge valuations where it was easy to have Lyft and other people start their own telephone taxi cab services. You have Elizabeth Holmes with Theranos being able to work a huge fraud on a lot of people and raise lots of money, where apparently, I've not done this, if you looked at the patents she had filed, you would have seen they were bogus. There are certainly other examples, the folks who rent space, office space in buildings. WeWork. It was a nice idea, but what stops someone else from, renting a suite of offices and then renting out to people by one? I work in such an office. If people aren't saying the diligence in the New York Minute questions for 10 minutes, what have you got that protects you? Why is that going to be infringed by a competitor versus it's easy to get around? Or are there already infringers? What sort of invalidity attacks are out there? I would say, if I was smart enough to be an investor, what are the worst invalidity arguments against your patents? Whether prior art or something else, what are the 5 biggest weaknesses? What are you doing about that? What are the best arguments of non-infringement? What are you doing about that? And then freedom to operate. And again, these are questions that are hard to lie about. Not impossible, but hard. The inventor, the CEO, whoever it is that's pitching you, is going to say, there's nothing out there. Or they're going to say these 3 things. Or if they're really sophisticated, they're going to say, here are the 5 worst problems. And here's how we're handling each of those problems. If it's freedom to operate, we're designing around this one. We're doing an opinion of counsel on this one, to formally look at it closely and say we don't infringe or it's invalid. We're working out a cross-licensing deal here. We're talking about acquisition or alliance or a formal standard here, and so on. We know what they are and we know what we're doing with them. If the entrepreneur says to you there are none, you've learned something really important about his thinking. And again, very fast. What are the alternatives either today or that are being developed in other small companies or laboratories, universities around the world? And what's going to be your iPhone 2.0, 3.0, 4.0? What sort of improvements are you looking at? So that would be the first level of diligence, and that's where people miss things. A lot of people do patent or have done patent prosecution where they don't even look at the prior art. They just listen to the inventor, write it up, file it. Again, that can be a very inexpensive strategy, and if what you need to do is get a patent on file, might be rational some of the time. In the United States, there was a ostrich strategy. People would deliberately bury their head in the sand and say, I don't want to know what the art is because I'll be accused of fraud on the patent office for not revealing that art later. The less I know, the better. Keep yourself, with blinkered rather than awareness. I very much don't believe in that. I think if you know about things early, you can start making the claims better. You can just start in a litigation knowing how you want the claims in their language, what do you want it to mean to minimize problems. But, knowing the best prior art and showing that the CEO knows it, first level of diligence. Did they underclaim? Did they overclaim? Are the infringement arguments good? Is it too easy to evade, or is it too broad? Is it not enabled? Both in CRISPR and a case I worked on for Enzo involving genetic technology, there's this whole issue of you worked it out in simple cells that have no nucleus, but doesn't work in more complex cells like animals, eukaryotes and prokaryotes, I think was the formal language. And are the examples enough to support the breadth of the claims? Again, even if your patents, trademark, copyright, trade secrets are good on their own, if you don't have freedom to operate because you're stepping on someone else's trademark, you've hired people and they've copied code from someone else, you've got a copyright problem. You've hired somebody who's brought trade secrets to the prior company, which was, again, I think an Uber problem. They hired folks from the Google car effort. You always got to watch out for that stuff. It's not enough to just have your IP be good against the other guy. If you succeed, you will be copied and you will be accused of copying. You will have the attack and defense, plaintiff and defendant problem. You've got to be ready and be ready to show that you are ready by being able to talk about this intelligently. And alternatives, even if people carry freedom to operate, which is wildly important, all too often not ignored, what else, even if you've covered a technology just fine, there's a saying that the customer is trying to buy a hole in the wood, not your drill bit. The drill bit is a means to an end. And if you have the world's finest carbide, aluminum, tech, diamond drill bit, someone's going to come along with a laser that punches holes or some other way of doing it. And so how else do you get that hole in the wood, and which ones make it irrelevant what IP that you've covered it with? And again, if you know what the alternatives are, in a position to say, here's our gap, our value gap, and why we're substantially better and worthwhile, knowing that there is other things people can do, that to me says you really know what you're doing. And of course, we've all seen the engineers and scientists or entrepreneurs who fall in love with their own idea and they really build it out without thinking about what does the customer want? Or when they get your first product, what are they going to want tomorrow? How are we going to improve it in terms of a good user interface, their real needs, the needs they don't even know that they have, and how do we use the IP we built to take, potentially much bigger and more powerful players and do judo and use their strength against them and build new opportunities. You can't always take a problem and make it an opportunity, but you always want to be looking. So do the 5 questions of diligence in the New York Minute. Do the full set of 20 questions from the tools I talked about, the 5x2 matrix, the 6 cycle, and the 4 levels of value. Questions such as, why is your budget? Who is your team? Who's your backup for the team? What do you do to brainstorm? The questions that come out of the 6 cycle. And then do full diligence, right? Inventors, the assignments, no mortgages, reviewing the files, the licenses, what's your cybersecurity, what's your trade secret precautions, all those other things. I'm not in any way trying to dismiss those. Those are going to cost a lot of money to do right, and they should be done before you do a big deal. But there's a lot you could do as a VC to screen better and then take your portfolio companies. You've invested in 10 and you know only one is going to really hit. Well, take the other 9 and improve their IP strategy and get them from, losing money or bankrupt to just making 1, 2, 3x on their money. Even if it's 100x, you're going to enormously improve your quality. So those are my thoughts on diligence.
As a final thought, David, could you also, most of the Indian companies that are developing patent portfolios, specifically speaking, are defensive in nature. They don't sort of try and enforce their patents, and they're obviously doing it in various countries. But all of the strategies at the back of the mind is more defensive in nature and not sort of litigate around too much. What, according to you, are some of the aspects that are good for companies that are defensive in their patent portfolio development? Not that they want to change themselves from being defensive to offensive, but within the ambit of being defensive, what are certain things, according to you, that they should be sort of considering or taking care of?
To me, the questions go together because I'm often helping entrepreneurs that are in a very similar position, very limited budget, very small, just trying to get the early stages out. And you can think of it as a developing versus developed countries, or in India versus, Germany, in terms of different stages of industrial development. But for better or worse, the way I think about IP, it doesn't really change that much. You need to be saying, I don't want to sue anybody. Huge waste of my money and my attention and all the rest. But I've got to be able to present a credible threat of that in order to negotiate what I want to negotiate. And, defensive, depending on how you're using it, can mean I don't want to get sued by other people, but I don't care if people copy me. Or it can mean I just want to defend my own IP, but I'm not worried about getting sued. The offense-defense metaphor can change very fast. So it's really, at least in my experience, and I'm a US lawyer, I've worked around the world, but most of my attention there, I think of these startups and as companies in India and Africa and in South America and in other places as a tiny mouse surrounded by hungry dinosaurs, as a very vulnerable new baby, as the leading edge of a very supersonic jet, the nose and the wings where the air really hits and cuts and burns. And they need more protection in some ways than the big company does. But there are ways of doing that, or at least starting to do that inexpensively. And of course, the IP budget you revisit each year, and as you grow, you can do a little bit more. But it's to take rational steps at the beginning that why you did it. You can describe to the outsider, whether it's in a license negotiation or a finance negotiation, or even a customer, why should I buy from you if you're going to be gone in 6 months? If it's the sort of product that needs continuing sales, service, and support. Why is your trademark going to be valuable over time? And you're going to build up a quality reputation so that people come back to you. I have competitors, you have competitors. Even we as lawyers face similar questions. We're not the only people who do this. We have to offer a plausible difference and then be reliable about delivering it. So focusing on the ancient IP of trademark and trade secret is certainly a good place to start. If the world you're in needs a patent and you just need to have something to point to, well, get someone who can do a reasonable job at a good budget and get it out there. It's always triage. Even the biggest companies are making those hard choices, and they aren't in a different place. But once you appreciate that it is important, these intangibles, even though you can't see them, touch them, feel them, you can start making better choices.
Understood. No, fantastic, David. Thank you so very much. Good to see so much energy in such early morning time of yours. Thank you very much, David. I think I would leave it open. If there are any questions that colleagues have, feel free to ask either through the audio or post it on the chat box, and I'll be happy to sort of post it out and reiterate it. Thank you very much, David. Again, we'll just wait for a few minutes to see if there are any questions that people have.
You bet. And by the way, I don't mean in saying this as if I'm talking to you, Tarun, to say you don't know it, but I think there are clients who don't know it and can be helped by knowing it.
Absolutely. No, I fully understand.
Anyway, I'm up on LinkedIn as well as available by email. I can always be contacted through Tarun, and you know, there's some additional materials from some old talks available, which can help you get started with this before you ever talk to me or hire me. But just, it's a better way to create value and a better life for all these people who, you know, it's tough out there. It's scary out there. And IP, to me, is one of the tools that governments can use to create a better life for people. As long as you accept it, it's not going to be static, and you need to be rational.
Absolutely. Absolutely. So I think Indian companies do require a lot of mentoring on that side, because we're all in the nascent stage of developing portfolios, haven't experienced much litigation. Licensing is also something which is relatively new to India, and there are not many success stories around it. And by virtue of that, it's important, I think, for us to have many more sessions of this nature. I have a question from Karthik, and Saurabh had asked a question earlier as well. Karthik says, how would the patenting or IP rights see itself in the R&D scenario, especially when they are going in for collaboration? So it's a fairly generic question in that sense, but maybe if you want to talk about it. And Saurabh had also earlier asked about large versus small companies developing portfolios. Is there a way that they should be thinking differently? How can smaller companies compete? Because even if you try and cross-license, it'll always be a huge ratio to overcome. You know, Huawei and ABBs and Emersons of the world have thousands of portfolios versus a company that may have just 10 or 15 patents and may still be sizable in terms of what they believe is their portfolio. So anything that you might want to comment there, David?
So a couple of comments. One is quite nasty, which is in excess of 99% of the patents, in my view, have no value at all or minimal value. So someone can have a lot of them, but it doesn't mean they're actually worth something. But imagine with me an Indian pharmaceutical company. I think Ranbaxy and Dr. Reddy's are leaders, and may well be others. And as part of, you know, taking older products that are generic and making them, sometimes attacking someone's patents and releasing the product early, all the normal things, they put some fraction of their budget into their own R&D, so that when Big Pharma comes up with a pill, India Pharma comes up with a somewhat improved pill, like a somewhat improved iPhone, a somewhat improved car, a somewhat improved, you know, water purification system, whatever it is that you might otherwise just copy. Now, when the company comes after you for infringement, and you're infringing their basic patent, you say, yes, you could stop me, or, you know, you could force me to pay a 10% royalty, but I have this really cool improvement to offer you back. And if we cross-license it, you know, maybe you only pay me 1% for my improvement, but I'm paying you 10% on my sales. But 1% of Pfizer's sales compared to 10% of a new small pharmaceutical company, you know, it can add up pretty well. And I remember recommending this in China years ago, that, you know, as you copy the iPhone, if you're getting a small percentage of Apple's sales in return for, you know, even a big percentage of your sales, it starts to even out pretty fast.
Of course.
And, you know, you can't accept the proposition, and I don't think people, and particularly in India, do. I know much less about Africa and South America. We can't invent, we can't create, we can only copy. I mean, if that's false anywhere, it's false in India, right? I've worked with brilliant expat Indian engineers and scientists. I mean, the level of thinking and creativity and ability in your country is phenomenal. The potential for your country to be the world leader, surpassing the United States, surpassing China, is phenomenal. All the potential is there. In my distorted, non-expert view of the world, some of the wonderful things Gandhi did included some imperfections around socialism and encouraging just traditional farming and not recognizing the power of innovation and stepping forward. But I don't know if that's true, and it doesn't matter if it's true. Whatever India's history is, it's absolutely in a position to just be at the very cutting edge. And those are always start out as little companies. You look at what South Korea has built since the Korean War. It's just absolutely amazing. And not every country does as well as South Korea Germany, Israel, Switzerland. There's a couple that really, do an excellent job, and other people, but you always want to drive yourself to be better and better. And that, when we worked on the Cipro case, Bayer, as big as it was, as old as it was, the amount of money they devoted to the Cipro patent portfolio was very limited, very triage, because in the early days, they didn't know that was going to be the winner. Sure. They didn't devote, the huge resources that in hindsight you would do, and they made a lot of really bad mistakes. So the big company conceals a lot of small departments and small groups, each of which are, fumbling along in the same way. And by thinking about it a little bit better, and again, this isn't the tool set that's the last word. This is as far as I've come. Sure. But if you think about it a little bit better, you can help people more, and you can help them for $1,000 and $10,000 and $500 and very small amounts of money. Maybe they draft their own patent and file it because that's all they can afford to do. Or maybe you take a 1 hour look at that as a lawyer and, you recognize its imperfections. You look at what big universities, Cornell, Columbia, University of Chicago are doing. They'll often divide the idea submissions into 3 categories, full good patent, a little bit more than, a little bit less than that, and a manuscript provisional. We take the scientific paper, put a cover sheet on it and go. All you have is an hour or two. And they build up portfolios that way, and they preserve some possibility of protection that way. And they don't have infinite resources. As big as they are, as rich as they are, as successful as they are. The resource gets that divide up. So recognizing, again, I think of it in terms of martial arts, even though your opponent might be larger and stronger and faster and younger, and certainly anyone I would ever fight would have all those things. There are always pressure points and knowledge you can use to at least even up the fight.
Appreciate it. Well, fantastic. I think you can just wait for another 30 seconds, David. I think they're out of time, and fantastic. What an insight. And anything else? Anybody would have a last question for David here? So we have a question from Amit Chatkar. It's common advice to avoid litigation, but isn't it contrary to the very basic intended premise visa to have an efficient enforcement system through efficient courts? Are there any developments or examples encouraging litigation as a favored strategy? David,
I will tell you as a lawyer, particularly when I had at my firm and before that, I love litigation. I started off as a general litigator. Being able to explain the technologies and complexities to a judge and jury, nothing made me happier. The trouble is that to do litigation right takes a lot of money. Now, there's ways of doing contingency and litigation financing and other things that can even up the odds. And again, compared to martial arts, some sort of warrior monk walking the streets of whether it's Delhi or Kyoto, you've got to be ready for a fight. You've got to look ready for a fight. You've got to get to a position where people say, let me work out a deal with you rather than fight. Every license negotiation, I think the other side is simulating litigation in their head and saying, well, if I don't take the license, what would it cost me to fight this, to wear them down, to, they want me to buy the company for $300 million. Well, if I sue for a couple of years and spend $6 million in litigation, I can wear them down, kill their patients, and I'll buy the company for $100 million. That's very good return on investment, a very good strategy. So you have to be ready. But when you actually are fighting, it's like that cartoon, maybe you've seen it, the two lawyers milking the cow, none of the milk is getting to the customer. I'm a believer in litigation, but it should always be strategic. It should always be a reason you're doing it. And if you can find a way to settle it, even imperfectly, in my experience, that's usually a good idea. There's certainly lawyers who believe in, go all the way and win. And there's certainly cases that need that. And you want to be ready to do that. But if you can build your portfolio from the beginning, how will this work out in litigation? Will this help me if I get sued or if I sue? Remembering, of course, your own patents don't provide a defense to infringement. Your improvement patent is not a defense to basic infringement. Your own trademark registration doesn't mean you aren't potentially confusing with someone else and so on. You've got to think through the fight in order to build the tools to mostly avoid the fight. And better courts help. I've had good success in the US courts, but we are expensive. Discovery gets a lot of good information out, but it's slow. I understand that Germany and some other countries have even better systems. I don't know enough about the Indian system. I've heard terrible things about what happens in Italy and so on. I didn't trust this trade secret court to the Saudi Arabian office. I made the terrible joke that if you win a trade secret case in Saudi Arabia, they cut off your hand. The trouble is, if you lose, they cut off the other guy's hand. So I don't want to litigate in Saudi Arabia. But that was probably a sexist, racist, irreligious, very bad joke. But the point was, I understand how the U.S. system works, its strengths and weaknesses, and I'm sure there's people who understand each of the different countries. But generally, the business person wants to focus on building their business. Otherwise, you can sort of catch the patent disease, put all your energy into IP and fights, and your family dies in poverty, and that's sad. It's happened.
Fantastic, David. What a pleasure. Thank you very, very much for contributing. We look forward to do another one very soon with you. And thank you again for a wonderful session and the enlightenment. And it went very smooth. And thank you again. Thank you, everybody, for joining in as well.
Thank you. Thank you.
Spending and sparing a valuable hour. Enjoy yourself with Mr. Biden, David.
Certainly a lot more than I enjoyed myself with his predecessor. I will. Thank you, sir.
Absolutely. Thank you very much.
Bye-bye.
Thank you. Thank you, everyone.